Yeah.
So it's actually quite important to be there in person.
No, I get that. I'm in total agreement with you.
As you know, most sports meetings, the decisions have already been made by the time the meeting happens.
Yeah.
They're also in the media before the discussion has taken place as well, usually.
Yes, or while it's taking place, it's linked,
Well,
as in the Racing Post today.
Okay, so I think we're going to make a start. Got a few people on the call now. So thank you everyone so much for joining. We have 3 partners today who are all really excited to speak to you. So firstly, we have Julian Pike, who is Head of Commercial Litigation and Reputation Management at Farrer & Co, and also the lead of the firm's sport practice. We have Tom Bruce, who is a partner at Farrer & Co and a key member of the firm's sport group. And we have John Taylor, Head of Bird & Bird's sport group in London. So if you guys would like to just briefly introduce yourselves, sort of tell us about your role, how you got into the firm and the nature of your work. So if we start with Julian, then head to Tom and then John after that.
Okay, thanks, Ella. So I'm a bit of a lifer. I've been at Farrer's for just the 31 years. So I left law school having done 3 years at Southampton reading law. And came here as a trainee. We were called article clerks back in the day, so it tells you how long ago it was. And when I qualified into the litigation department, and basically I've been there ever since. I have specialised in around reputation management and sports related work, and I find myself sort of having to sort of manage that sort of wider department. So I've been involved in this work, for the best part of 30 years.
Shall I go next? So I'm sort of half 30s. I've been at Farrer's now since I qualified in 2008. I was at Durham University, Nottingham Law School, and I chose Farrer's because of the variety of work. So yes, I'm a massive sports fan, love playing sport, etc. Always keen to get in. Was always keen to become a sports lawyer at Farrer's. But I also wanted to spend some of my time doing other stuff as well. So and we'll talk about this possibly a bit later on, but so I'm a corporate partner at Farrer's, and I probably do sports stuff 50 or 60% of the time. And my sports work is governance advice, it's transactional advice, typically media rights deals, joint ventures, etc. And it's structuring for hosting major sporting events. It tends to fall in those 3 areas. And it's to high-profile governing bodies, international federations, typically. And I'll save some of the more detail for later, just as a brief intro. But I've been at Farrer's since then and had a comment at the RFU in 2014, working in their legal team, and that was very much focused around the World Cup. Thank you.
Thanks, Tom. I'm John Taylor of Bird & Bird. I did a law degree here, then I did a law degree in the States. I practiced in New York for about 7 years. And then almost 25 years ago, I came back here and worked first for a small firm called Townley's, then Hammonds, and then Bird & Bird, solely doing sports work. So 25 years next year, I think it is. And there are, depending on how you count them, 21 full-time sports lawyers at Bird & Bird. Half of them do non-contentious work, similar to what Tom's just described, and half of us do contentious work, which for a sports lawyer includes drafting rules, applying rules, enforcing rules, defending challenges to rules. It involves a lot more than that, but that's a lot about what we do. I'm on the contentious side. I'm a QC for them from doing advocacy in Court of Arbitration for Sport and other places. I do a little bit of governance work like Tom. And the other thing, I suppose, that is an overlap between the 2 parts, the contentious and non-contentious parts, is the rule drafting. Because the non-contentious lawyers think they're contracts and they can draft them properly. And the contentious lawyers think, well, I'm going to be the one who has to defend this in front of the tribunal, so I want to draft them. So there's always a bit of a fight about that. But that's a very brief overview to our practice.
That's great. Thank you all so much. So I'm going to pass over to Hannah now, and she'll get started with some of the questions.
So we're going to I'll start with Julian and Tom. So the first question, I know you've both touched on it slightly, but just go into a bit more depth. What does a typical day look like for both of you? So if you want to answer separately.
Thanks, Hannah. I don't have a typical day. There's no 2 days are the same. What I'd say is typical is like get up in the morning and I think I know what I'm going to be doing that day, but invariably it doesn't happen like that. So a lot of what I do is based around reputation management work, and that very much then evolves fairly speedily out of events. So in a sporting context, I might be advising a governing body that's got an issue which has reputational aspects to it. That could range from dealing with a straightforward, as far as I'm concerned, fairly straightforward matter with the press, where there's a sort of defamation, privacy type aspect to it. It might involve an individual who is harassing somebody within the organisation, whether that's online or directly physically. It may be that there is an ongoing issue that the organisation has. So, for example, they might have an employment case where there are aspects around that which I get brought in to give advice on. In the context of individual athletes, it's the similar sort of issues that arise, but actually, they were just as much a target as governing bodies in many ways, and sometimes more so given their profile. So, for example, I've recently been acting for a Premiership player who's been the subject of blackmail. So it throws up various different issues in the context of sport. I do some genuine sports disputes work, such as the type that John was describing in terms of dealing with disciplinary process and the like. But probably most of what I do is in and around that reputational piece, in amongst acting for being a wide variety of clients. Over to you, Tom.
Thanks. So, I mean, I think John's absolutely right, and I typically will work on what I would describe as contentious governance matters with Julian or someone in Julian's team to make sure that what we're doing is very much aligned in terms of interpreting the Constitution, the company law, etc., but making sure that we're doing that within the context of a contentious environment. That's incredibly important. Completely agree with John. In each of the different areas that I've mentioned, so on governance advice, I've done a huge amount of work on the code for sports governance and helping governing bodies implement that mandatory code for governing bodies who receive government lottery funding, and that was a big part of what I was doing for probably 3 or 4 years when the code came in. Well, I found that governance matters have become increasingly contentious over time. When I say that, I mean disaffected member stakeholders who are interested in removing a chair or a vote of no confidence in the board, or member activism in the sense of looking to pass resolutions, bring resolutions to meetings to invoke change. And in my view, social media, the ability for them to communicate and coordinate has really helped that, not just in sport, frankly, but has helped with shareholder member activism over a period of time. So actually quite a lot of that is contentious work. The non-contentious stuff tends to focus on making sure that clients have a constitution that is compliant with what they would describe as as best practice, or they want to be best in class. And they might look at the code if they've got lottery money, and they might say, well, okay, fine, I understood, but I'd like to do this, that, or the other, and I want to be at a better level than that. Or we are looking to refresh things after a contentious issue. So there's been something that's come up that's prompted that change, and typically Julian and I will often, I'll be the fallout often from a dispute scenario. So on a typical day, I might be giving that kind of advice. A lot of the in-house FDs or lawyers at these sports bodies will call me, and I think they find it efficient to have 10 minutes on the phone, just sense checking, particularly around conflicts and perceived conflicts in sport, of which there are many. There's actual conflicts, but also perceived conflicts we have to be very careful about in governance terms. So I have that kind of relationship, or they might want to meet up, but over the last couple of years, it's been a call or a Teams catch up. And then in terms of the second area, transactional work, those will be very, very consuming. And I'll talk a bit later on about the European Tour transaction that I've been involved with recently to give you a sense of some of the issues. But if it's a media rights deal or a reorganization or a joint venture, then that will potentially be a quite intense period of time to negotiate and agree those transaction documents. And recently, those sorts of deals have been on the cards, not least because bodies have been struggling for cash flow. So there's been an element of needing to bridge a gap, or I've been working with our banking team on taking advantage of some of the government debt schemes or otherwise working with those guys. And then when it comes to structuring sporting events, and the most obvious for us, I suppose, was London 2017, did a huge amount of work around that. It will be making sure that the organising committee, the vehicle itself that is going to run that event, has the right governance structure in place, has the right constitution, and the various stakeholders have the right interests. And that will go on for a lot longer typically, because there's usually quite a long lead up to a particular event, and those sorts of entities, funding at DCMS, etc., will move slightly slower potentially. So there's those sorts of issues. But like Julian, wake up, and variety is what I've always really enjoyed, but you just don't know what's coming next. But that's part of what makes it interesting. John.
Well, I must agree with both of you that it's usually when you've got a calendar day where there's nothing in it and you think this is going to be good, I'll be able to catch up on things. That's usually when you get 3 or 4 calls from people saying, I need some urgent advice about this or that. So a typical day is difficult to say. If it's in the office, it will be looking at, well, it depends for me on whether or not I'm working to some court deadline or arbitral tribunal deadline, in which case we're all desperately trying to get witness statements or legal briefs or whatever it is, skeleton arguments, in time before the deadline. If it's not, it'll be speak today. What have I done? I've spoken to the British Horse Racing Authority about a governance issue. I am now looking at for FIA, International Federation for Automobiles, which does Formula One, about a dispute about how they scored a particular Grand Prix. Probably guess which 2 teams are arguing about that. And I'm looking at something to do with the dispute resolution mechanisms for the Commonwealth Games next year. Often, a lot of what I do is for international sports federations, and there can be a lot of travel, or at least there used to be a lot of travel, and it's picking up again, as I just talked to Julian about. So, for example, the ICC, the International Cricket Council, is in Dubai. So I went there last week for some meetings. And you may go to a committee meeting or a board meeting, whatever it might be, a working group, could be anything. I do a lot of work for the World Anti-Doping Agency in Montreal. I chair a couple of committees and they meet all over the world. Usually involves a fair amount of air miles, although my daughters tell me I'm not allowed to do that anymore. If we're litigating a case, it could be in the UK. I just finished I was acting for the Football League against Derby County, who were challenging their 12 points deduction for going into insolvency, and they eventually withdrew their appeal and took the 12 points plus another 9 for other breaches. It could be if it's for an international federation, it's probably going to be in Lausanne, because that's where most of them are, where the IOC is, and the Court of Arbitration for Sport is in Lausanne. So I must have done that journey, I don't know, 100 times by now, either to see one of those sports federations or to appear in the CAS, the Court of Arbitration for Sport. So it can be. I suppose the other one is investigations. We do large investigations, and they start about corruption, but as Tom says, they usually end up as governance and reviews, because corruption is usually allowed to happen because of bad governance. So if you're doing an investigation, you might need to go and meet some witnesses somewhere. I had to go to a secret location to meet with Gregory Rodchenkov, who hopefully one or two of you will recognise. He was the director of the Moscow Anti-Doping Lab, star of a film called Icarus, if anyone wants to watch it on Netflix. And he was the guy behind the state-sponsored doping of Russian athletes, which has kept me quite busy for the last few years. So there was a lot of travel, and it's picking up again. But at the same time, it could be a week in the office where you are either filing briefs or meeting court deadlines, or you are advising clients in meetings or on the phone or on email, like Tom and Julian have discussed. That is my untypical day.
Thank you guys so much. You guys sound like you do really interesting work. I mean, clearly varies from day to day, week to week. This kind of links to, what you've already covered. It might not be so straightforward to answer, but is there kind of typical matters or typical ways you advise clients on? If you want to go around again, we can start with John this time if you want to start, and then we'll go around in reverse. We'll go to Tom and Julian.
Say again, typical matters or typical, what was it? Sorry, I missed it.
Sorry, typical matters or typical advice you give to clients. Obviously, it might not be as straightforward as that, but if there's anything.
Well, yeah, it depends on which. We have people who work on contracts, so broadcasting contracts, sponsorship contracts, sponsoring stadiums or shirts, clubs, whatever it might be, individuals, data rights, event hosting agreements, sort of thing Tom's talked about. For the contentious side, it would be drafting rules. So, for example, we drafted some for the International Paralympic Committee for the Paralympic Games just gone. We drafted some protest rules. You may have spotted that people have been saying they want to be able to protest on the podium or elsewhere. And that raises an interesting issue of freedom of speech, but also many athletes say, look, that's my moment in the sun. I don't want to be, you to use it to exploit or to promote some cause. You should do that elsewhere. So there's a conflict there, and the question is, where do you draw the line? We draft rules like the controversial ones of the World Athletics regulations on eligibility for the female category, which I drafted and which we defended in the Casta Semenya suit. And I can usually get people to start an argument with me quite quickly just by mentioning that. So maybe that will keep people off. So we could be drafting rules. We could be advising on whether someone has breached the rules. Did some of that yesterday in a tennis case. You get a report of what happened, and you have to decide whether or not that amounts to whatever it might be, an anti-doping rule violation, an anti-corruption code violation, a breach of ethics, whatever it might be. Might be something on the field, usually something off the field, the stuff I do. Or it could be, drafting witness statements to support whatever argument you're making in front of whatever disciplinary panel you're in front of. In the UK, if we're acting for a domestic governing body, it's usually there's an organisation called Sport Resolutions that Tom and Julian will be very familiar with, which is a sort of sports specialist arbitral service designed to have people who are familiar with sport, familiar with sports disputes, and able to turn things around quickly and effectively. In sport in particular, speed is often of the essence. So, for example, take the Derby case. If Derby are going to get 12 points for insolvency and they're going to challenge it, you need to know pretty soon whether or not that 12-point deduction is going to stand. Because if you're Derby or if your other teams around near the bottom, you need to know who's going to get relegated. So for that reason, or because it's a dispute about whether an athlete should be banned or not, and there's an event coming up, or a selection dispute before the Olympics, they're usually under significant time pressure. So many of the disputes we do are done in very quick turnaround. The EFL case with Derby is a 3-week case from start to finish, which I can tell you leads to a lot of fairly miserable long nights. I've forgotten the question now, but hopefully that sort of answered it. Tom or Julian, help me out.
Yeah, thanks. And I think all of this dovetails hopefully for everyone, but the thing I'd say is that the advice is one thing, the company law is one thing, the interpretation of the articles is one thing, but then the application of providing advice that is applied to not just the scenario, but the personalities in sport, because there is such passion amongst the stakeholders that when someone feels like they are a disaffected member or board member or home country of a British organisation, there is a really important relationship element to this. And a lot of the governance advice that I do will not just be to the FD or to the General Counsel. The chair is going to be really interested in this, because it's going to affect how, or the president or whoever it is, because it's going to affect how they run their members meeting, board meeting, whatever it is. And so just having a sense of the personalities and the relationships and tailoring the advice to the situation is really, really important. And that might be that there's a disputes element that's fed in, but typically it's just getting used to with experience the way that sports bodies work. And I would say a lot of what we try and do is educate and inform passionate volunteers or other servants of sport, so that they understand, as members, for example, or whatever other role they're in, perhaps the protections and the rights that they have, which they may not understand, because a lot of what can come forward sometimes will be a misinterpretation of the constitution or the rules or the policies or the terms of reference of the committees or whatever it is. So we may well often in those scenarios try to bring someone along with us, not be too adversarial, and make sure they understand actually, the point you're making is fine, but have you thought about these? There's different other elements to consider. So we're often trying to bring people with us, and a lot of the noise and emails and disaffected communications can come from a minority, particularly in the lead up to important AGMs or important meetings where there are important resolutions being put to those meetings. And I've attended many general meetings, AGMs, to explain to the room in very much in a neutral capacity that this is what's in front of you. We Farrers think it's best practice, it's compliant with the code, whatever else, to make sure that in that moment, when a member asks someone on the board a particular question, there's someone who can answer it on a neutral basis to calm the sense in the room. And that can be a really, really important role to play amongst those sorts of governance situations. Contrast a high value media rights deal, which is a bit more hammer and tongs negotiation with the other side on what we're going to get out of the deal, and I'm dealing with lawyers, effectively in-house lawyers or lawyers on the other side, who are just not, it's just a very different environment. So applying the advice to who's in front of you, can't emphasize, I think, how important that is, and it will vary in each case. Julian.
Thanks. Just to sort of perhaps bring it back to the audience to some extent, because you've obviously been hearing about some of the things that the three of us typically do. When somebody comes into the firm here, one of the things that I'm always quite keen to identify about them is whether they are a contentious or non-contentious lawyer. If you are a non-contentious lawyer, in the main, most non-contentious lawyers do not like the contentious work because it's too litigious, and they find it sort of fairly stressful. And I make this point, one, just to throw that out there for you to think about in terms of, as you go through your legal careers, to think about whether you are a contentious or non-contentious person. But secondly, if you are interested in sports work as a lawyer, you will almost inevitably find a niche whether you're a contentious or non-contentious person. So, for example, we have got banking lawyers here, and you'll say to me, what the heck has that got to do with sport, right? Well, actually, football clubs need finance to build the stadia. They need funding to buy players, okay? And so an element of our banking practice is around that sort of finance work for sports bodies. There may be also funding that is going into governing bodies, albeit less common than a football club wanting to, redevelop a stadium or, future sort of fund itself by basically mortgaging its ticket receipts or TV revenues in order to go and buy a player. Equally, you could be very interested in sort of commercial property. And again, you wouldn't first think of how that connects into sport, but then you think about it, well, actually, if a club wants to redevelop its ground, it's going to need some commercial property legal advice. It's going to need planning. It's going to need construction lawyers involved. A lot of our employment practice involves giving employment law advice. And that's very wide ranging. It would be from straightforward sort of hire and fire type work, but for us, it will get and cut across to the sort of discrimination, harassment type issues that arise. And we have a very significant safeguarding practice here at the firm. And it's one of the big issues of the day in the last 5 years, the amount of safeguarding matters, both historic and current, that arise in and around sport. Sadly, if you happen to be of that persuasion, sport is a good thing to get involved in because there are lots of young people involved. And it comes up at every single level, governing body, club, whether that's a major club or it's actually this little football club around the corner that the under-10s go and play for. So the point I'm making is there's a wide range of different work types within law that you can get involved in, which then have touch points with sport. The other thing I'm just picking up, I just mentioned this point, and I've slightly touched on with safeguarding, is that I think probably like other areas of life and law, you see trends that emerge, and there'll be something that's blowing hot for a period of time. So I've mentioned safeguarding is a very good example of that in the last few years. You've seen all the issues coming out, particularly at football, but then gymnastics, both here and overseas. You've seen it in the context of British cycling, perhaps, where you've got sort of bullying allegations of adults and not involving children, adult athletes. You've seen it in a sort of Paralympic context. One of the things that I'm doing at the moment in terms of trend is dealing with racial online abuse. It is a scourge of our modern day society, but it's something that is actually very relevant as we speak. And therefore, it's a question of looking at different ways organisations can deal with this problem, trying to be perhaps a little bit inventive around it, trying to create genuine consequences for somebody, as opposed to a certain amount of sort of slap on the wrist type outcomes that perhaps have happened in the past. So definitely think about the breadth of work, legal work, that actually law and where law and sport sort of coincide. But also, being mindful that actually there will be periods of time where all of us will be deeply involved in a particular work type or issue, and that will sort of pass, and actually you'll move on to, in many ways, to the next one.
Julian, can I just leap in before we go to the next question to say, and I'm sure you'll agree with me with this, that many of the non-contentious lawyers I've met have been extremely contentious people, and that the transactions that they get involved in can get very contentious. In fact, some of the most heated meetings I've been in terms of adversarial conduct and argument have been with non-contentious lawyers, excluding Tom, of course, who's a very calm and mild man. I don't want people to think, actually, there's a serious point, which is non-contentious lawyers often have to do very significant advocacy and sometimes pretty adversarial context, and they have to argue their position for their clients. So it's a really important distinction. I agree with you, and you need to make a decision relatively early on. But it's not as if you say, well, I don't like an argument, so I'm going to be a non-contentious lawyer, because they can be extremely argumentative.
Yeah, I don't disagree with you, John. I just you just see young lawyers sort of come through and when they, for example, have to put their foot in a door to serve a summons or a claim, you know, it's have you got the mettle to do that? And some people genuinely don't like the cut and thrust that you and I will be quite used to. You know, perhaps with a sporting background, we quite like the sort of competitive elements of it. But yeah, I agree. There's plenty of non-contentious lawyers who, you know, it's easier to have a row with them than it is to have a sort of decent conversation.
Thank you. Yeah, I mean, very interesting points that I didn't see coming, but I mean, yeah, as well, like very important stuff you touched on as well, like Julian. Just a last one for all of you, then we'll break down into separate questions for each speaker. How has the sports industry been affected by COVID, and what has changed about the nature of your work? So should we go back, start with Tom this time, then go from there?
I think the funding issue that was created by the lockdowns was a significant factor at the outset, particularly, and advice we were giving around directors' duties, making sure that if they were trading, they weren't trading whilst technically insolvent, and then working, as I said, with our banking guys around looking at debt solutions to bridge that cash flow issue. And then particularly everything went online. So were those organisations set up to conduct meetings and govern themselves on a virtual basis? Well, most weren't, but actually the government passed regulation to help out with that as well. But most bodies came to us to say, look, we've got this going on. How do we play it? And interestingly, around that, many of them have had much better attendance and engagement from their memberships because of people being able to engage online than they perhaps would have done had they been required to go to the meeting or asked and go to the meeting to spend money, etc., to go to meetings in person. But otherwise, in all honesty, a lot of it has been business as usual. I mean, we've been incredibly busy over this whole period. But I would say, and I'll talk about the European Tour separately, but I would say that there's been transactions prompted by that need for cash and the whole slowdown of sport not being on for that period of time and events being difficult to host, difficult to mobilize players, creating bubble environments, all that kind of stuff has made it difficult for those organizations.
I'll come in next to Julian, if you don't mind. I agree with that. The two other things I'd say, I spent a lot of time, again, with the Football League when the season stopped in March last year, trying to work out what to do if the season wouldn't start again, because unsurprisingly, they didn't have many rules that said what would happen if the season stopped halfway through. And in those situations, you fall back, as Thomas said, on your memorandum and articles of association and on principles of fiduciary duties of directors, and you soon work out that you're going to make someone unhappy. There's not going to be a solution that will make anyone particularly happy. And as you may know, what happened in the end was Leagues 1 and 2 didn't recommence. They could have done, but didn't want to behind closed doors, whereas the Championship clubs did. And so one of the things you had to do with Leagues 1 and 2 was decide, well, what does the final table look like? What do we do? Do we just freeze it from the day they suspended the season, or do we change the rules somewhat? And it was Tranmere, I think, who got relegated, who were extremely upset with the conclusion reached, threatened to sue, but didn't in the end. The other thing I think about the COVID, and again, I will exclude Tom and Ferris from this, but I'm sure that there were many transactional lawyers who reached nervously for their contracts to look at what they put in their force majeure clauses, when none of them ever had to think about force majeure clauses because they just reproduced the boilerplate from the last 20 transactions they did. And then suddenly everyone had to look at their force majeure clauses, and millions of pounds could have turned on what they did or didn't mean. I was glad at that point I was a litigator, not a transactional lawyer. Julian.
I thought you were up for a fight, John. I think in terms of a commercial, just picking up John's point, I mean, certainly our commercial team did a lot of work around looking at those sorts of clauses and the consequences of events not being able to complete. And you think about it, you know, it's not just about the sporting context, but it's also about what goes on around the sport. So something as dull as a catering contract suddenly, you know, becomes really important because there's a lot of money that resides on it, given the number of, you know, games that haven't been played in the rest of the season, or the fact that you know, a big event like a Wimbledon or a, you know, Henley, you find that actually there's a lot of money riding on those sorts of events not taking place. I think one of the things that sport really struggle with, and both of Tom and John touched on this, is that, you know, they just weren't ready, and unsurprisingly, they weren't ready to simply have the tap turned off, and it had a major impact on all of the organisations, governing bodies through to clubs in terms of their finances, and a lot of them are still struggling to recover now. I mean, you know, a number took haircuts in terms of salaries, for example, and that's still having an impact today. So I think it's going to take sport quite a while to recover. I think there's obviously some sports, football being the obvious example, which will bounce back more quickly. Cricket's doing pretty well. The RFU's got quite a way to go. I mean, those have been the three big sports, but the sort of quotes minor sports are definitely going to find it tougher to get back to where they were 2.5 years ago. To some extent, it didn't directly impact on me and my practice. People still had issues. Perhaps sometimes some of the issues they ended up dealing with were a result of COVID, where people were, you know, bored, not able to do what they would normally do during the day, and did things online, which they frankly shouldn't have done. So there's a bit of that took off, but I think it will take quite a while for sport, all of sport, to find its way back to somewhere where it was, you know, just over 2 years ago.
Yeah, I can imagine. I'm just cautious of time, so we're going to break it down a little bit. So I'm going to pass to Ella. Ella's got questions for Julian and Tom, and Adam, I believe you have some for John. So Ella, do you want to start? I think you've got a question for Tom, first of all.
Yeah, that's right. So Tom, you mentioned earlier about just briefly your work with the European Tour. So I was wondering if you could just tell our audience a little bit about the matters that you advise the PGA European Tour on.
I can't go into too much detail, obviously, but a lot of this is in the public domain. So I just thought it'd be interesting, hopefully, to give a sense for where they've come from over the last year or a year and a half, particularly. And we've been acting for them for a lot longer than that. But over that last period of time, where golf as a sport was, and the European Tour was a decision largely around, you know, do we look to, particularly with COVID, do we look to our larger cousin which is the PGA Tour in America, to build out the global golfing governing body network, or do we consider a disruptor investment from private equity and potentially form, you know, some sort of new Premier Golf League, or a focus on top players, or whatever that might look like. And I think that's just a really interesting thought for everyone to have about how sport, and you see this in football, you're seeing this in other areas, that where it is a business, and there are going to be competitors. And it is not just the case that any of these organisations will stay in place in the way that they always have. It is moving quickly, and private equity or venture capital investment is happening. Rugby is an example of that. And so what was really interesting about that transaction, and it ended up being a strategic alliance, in inverted commas, between the European Tour and the PGA Tour. So to talk about getting aggressive on telephone calls, I was talking to the Americans at 10 p.m. every night, and all I would say on that is you're looking at who you're up against. So are you going to be adversarial to someone or not, and are you doing that and just to have a reason why? So it's not just being aggressive for the sake of it, it's picking the timings to do that, and judging the personality in front of you. And I can tell you, typically, the top American law firms can be quite aggressive in the way they go about things. So to bring them with you and then be aggressive on the right things, I think that's the important thing. It's not just being able to sell for no reason. But so ultimately, the European Tour decided to enter into a transaction within the sport to build out that framework. And when they did that, they had advice and input from a range of non-executive directors who had fantastic experience across all different sports. And that was fascinating input around what are your important things? Well, they're the players and the events and the things that you do. And the challenge, of course, with private equity or venture capital investment is ultimately those organizations are going to want to see some sort of return over time. And how are you going to deliver that in, say, 5 years' time when you just don't know where your sport is going to be? And is that genuinely in the best interests of your membership, of the players, or is it not? And then the only other thing I want to say on the European Tour is that, you know, in other scenarios, we've seen it with Newcastle as well. There is now a funding arm from the Saudis who are looking at, and it's in the news, who are looking at the Asian Tour, which is in theory, or certainly now, is a competitor of the European Tour, to look to fund the Asian Tour to the tune of 10 events with better prize money, etc. And Greg Norman is fronting that up. And so it's thinking very carefully about the competition law landscape and what it looks like for players to be entitled to play on the European Tour and in other events as well, and whether or not the European Tour or the PGA Tour might release those players to play in certain events. So competition law feeds in very heavily into that, and it'll be interesting to see how it all plays out, but we're looking at that very carefully. And in amongst all of that, we're looking at their constitution, at their terms of reference, the way they're set up and have been for a long time, to look to ensure that they have what they need in terms of best practice. But it's just an example where there are multiple elements going on, and where the last couple of years has really accelerated the pace of change. So that will apply across different organisations, but I thought it might be interesting for everyone to hear a little bit about the European Tour.
Yeah, that's really insightful. Thank you. So moving on to Julian now, I just have one question for you. So I know that you've obviously worked hard to increase female participation in sport. So I was just wondering if you could talk to our audience about how Farah & Co helps clients to increase women in sport and how that forms part of their strategy.
Yeah, that's fine. You have obviously been doing your homework and picked up on a report that we produced a couple of years ago, which looked at female participation in sport. And this was really looking at the difference between the growth in actual playing participation, which has grown, frankly, exponentially in the last probably 10 years or so. And then the failure of sport to have women participate in the decision-making side of sport. So what we did was we produced a report which contrast the governing bodies who had made a significant investment in women being on the boards of those organisations, and then the professional clubs where actually there was no representation of any note. So to contrast that, this is 2019, over 70% of the governing bodies in this country had 30% or more female members on their boards. When you looked at county cricket, Premiership rugby, Premier League football, Championship football, 2 of those 4, cricket and rugby, did not meet the 30% target that existed for governing bodies. And sort of if you drill down a bit more, for example, of the big 6 football clubs, although 2 or 3 of those clubs might be struggling to be in the big 6 going forward, but anyway, of the big 6 football clubs, 35 board positions, only 4 places where you had female board members. And so we drew out this distinction whether you've got a problem here, because if you're trying to grow female participation in the game, then how can you really do that authentically and successfully if you do not have representation of sufficient females in the boardroom. And we sort of very much highlighted this as an issue. And, you know, where sport is going to grow in terms of participation by and large is by the growth of female participants across the sport. You know, if you look at male participation in sport, all you've seen in the last probably 20, maybe even 30 years is a decline in men playing football, men playing rugby, men playing cricket, and so on. Where there's actually been growth is in around women and girls sport. So we produced a report that sort of drew attention to this and how we put it into practice. First and foremost, most commonly is through the likes of Tom and his work in the governance, because obviously that's where it starts in terms of you put in place governance so that it encourages female participation. And I should obviously add that the same applies to ethnicity. You want to encourage a mixed, diverse board, and so that doesn't just mean women on the board, but it means people of different colour and different backgrounds. But then, you know, it also comes in a practical context of where we would have an issue arise, and there is clearly scope where you ought to have a diverse group of investigators or a diverse panel which are going to make a decision in relation to an issue, so that actually you are bringing diversity into play in a sort of genuine active role in resolving a matter. Okay, so you can see it at different levels: board level, you can see it in sort of disputes panel level, you can see it in investigation level, you see it, you know, genuinely a wider governance thing. And you're seeing in cricket at the moment, one of the things that's coming out is the ECB insisting on there being a much greater diversity around ethnicity on boards, forcing it to happen by, so I think it's March or April next year, which is, you know, people going, hang on a minute, that's a very short period window for us to make those changes. But so you are seeing it be active in that way. And the other thing we will do is a slightly softer side. So we will look to create informal forums and where these sorts of issues can be discussed. And actually, by putting people together, getting people to discuss these issues, it allows them to go away. Hopefully, we provoke some thought, and actually they can start to put in place some of the things that we've been able to talk about and discuss with them. But hopefully that answers your question.
Yeah, that definitely does. Thank you so much. So I'll pass over to you now, Adam. You can ask a question.
Thanks, Ella. So, John, working in litigation, you've been involved, obviously, in some huge cases, like the Russian doping case you mentioned earlier. As a cricket fan, personally, I know I got distracted reading about the spot fixing case from 2010. Because obviously these are all so controversial, I just wanted to ask if there are any times that the media or the PR side of things, is there been interruption to the work you've done?
Well, that spot fixing case is a good example. For people who don't know, that was 2010. The Lords and Oval tests were, there was, what's his name, Mazin Mahmood, who's since spent some time in prison, the fake sheikh. He did a sting and caught the agent for Butt Asif and Amir and got him on tape counting out money in a hotel room and putting it in a brown bag and taking it away. And we did get enormous, in fact, the News of the World printed it, which shows how long ago it was, on a Sunday. I think they printed 15 pages that week. It was front page news for everyone. And it was much bigger news in Pakistan and India. And we had to act pretty quickly. We provisionally suspended the 3 athletes, and they challenged us in a hearing in Dubai. And we went to that hearing, and there were probably 20 camera crews outside. And the Pakistani press were saying that the case had been contrived by the Indian Special Forces to embarrass Pakistan and its captain of its team, which was an interesting theory, not borne out by the evidence. And the media there had a real impact. The lawyer for Salman Butt we presented all of our evidence, included all the videos that the guys had taken, transcripts, phone calls that had been made to the players, pretty damning evidence. And the lawyer, who was an interesting chap, said to me quietly during the break, if I'd known how much evidence you had, I would have never taken this case on. Then when the provisional suspension was upheld, he went outside and talked to the press, and he said, this is all a racist conspiracy against my clients, which I thought was a bit troubling. The other, does it matter? You don't pay any attention to it? No. But one of the things that happened in that case was the police, the CPS were involved, the Metropolitan Police and the CPS, and what they did, they were going to bring criminal charges. They didn't want us to carry on with our case because they wanted first dibs on all the witnesses. In fact, they told us there was a rule that said sports bodies have to wait for the criminal authorities. So I went and asked the criminal lawyer, and he said, no, they just made that up. So we went ahead anyway. But just before the judgment came out, they charged the players, and they did so to trigger the Contempt of Court Act, because it meant that you couldn't report on it in a way that would prejudice the criminal trial. So I suppose that's the way that the media coverage affected that case. It prompted the CPS to charge much more quickly than they would have done otherwise. The other case that where media attention really has impacted is the Semenya case that I mentioned. It's an incredibly controversial case, mainly because it's not understood by people and it's badly reported in the press. But it does essentially come down to the issue of gender identity against biological sex, and whether a sport is entitled to say we respect people's gender identity, but on the sports field it's biological sex that matters. I suppose is how I would summarise it in one sentence. But we have, obviously I'm incredibly biased here, okay? I'm an advocate for world athletics, so take what I say with a pinch of salt. But we've taken that case and we've argued it in detail. We had a week-long trial, 12 experts in hot tubs and a very expert panel, and they agreed with us. They agreed that the rules were lawful and complied with human rights legislation and so on. But we couldn't, the award couldn't be published in full because there was some information about it about DSD athletes who are known to be DSD athletes. It was important evidence, but we couldn't publish it. And what happened was, that was then challenged before the Swiss Federal Tribunal, and they upheld the decision and said the rules, we agree that the rules are fine. It's now in front of the European Convention of Human Rights, so we'll see if we're lucky a third time. But in the press, what's happened is all of the experts for the other side have gone out and re-argued their case, and re-argued it on Twitter, and ignored the fact that there's a counter-argument, and it's a counter-argument that prevailed. So we have won in the court and lost in the court of public opinion. And it's very frustrating because I'd quite like to, in fact, I have done a few interviews, and but we've got to be very careful what we say. And it really does trouble me because it's quite hard to understand the case. You've got to work hard to understand the complexities. Journalists don't do that. And therefore people who read the paper don't do that. I have to say, I'm just as bad, because I will read a story in the press about a case I know about, and I will think, that is a terrible article. That is so misleading and so wrong that journalists should be shot. Then I turn the page and I read a story about something I don't know anything about, and I just say, oh, well, that must be right. So it just shows you need to be very careful, because I'm sure Julian and Tom would agree, when you read about something that you're working on in the press, it is usually, well, you're lucky if it's about 50% accurate. Adam, that's my answer.
I very much endorse that, John. I think I've done one case ever where I read a story and thought that was 100% correct. Mostly you do have to take what is written, particularly when you need to understand the sort of political agenda that the paper has, and the standpoints that are made, and also take account of the fact that there is a desire to sell newspapers, so they are going to make it as, sort of, to coin a phrase, as sexy as possible to make it interesting to readers. So when you put together the political agenda that's behind a paper, and that doesn't matter whether it's the Times, the Guardian, the Sun, Mirror, doesn't matter, or even the BBC for these purposes, and then you put it together with the commercial need to sell papers, sell advertising space for TV, for example, then you are going to get a version of history as opposed to a flat narrative, which is entirely to be believed.
Brilliant, thanks for that, guys. Really interesting insight. And I think Hannah is now going to field some questions from the audience.
Yeah, so I'm going to open the floor up to anyone who is on the call currently. If anyone wants to raise their hand to answer a question, or just unmute your mics if there is anyone who wants to answer any questions. If not, we do have some pre-sent ones and people who can make it. We have a question from Grace. Grace, do you want to go?
Hello, yes, can you hear me? Yeah, perfect. So I just wanted to ask, from kind of where we are now in our studies and our legal career, in terms of kind of looking at law firms and where to apply, what is your biggest tips for getting into sports law? What would that route look like for us at this stage? Is it a case of kind of going into commercial law and then it happening later on? Do you look for specific firms that maybe offer routes into sports law? Yeah, kind of what's your biggest advice there?
Shall I kick off on that?
Yeah, go for it, John.
Thank you, Grace, for that. There aren't many firms that do a lot of sports law, and therefore many sports lawyers also do other things, and then the sports group sort of forms when sports work comes in. So it's not a big market. I write a sports law book. These guys contribute to it too, and we sell 500 copies per edition around the world. So it's not a huge market. You need to bear that in mind. It's very competitive. There will be firms that not only have enough sports work for the group, but will also allow you as a trainee to rotate through the sports group. We do that. I'm sure Farrers do that too. And there will be a few others. There won't be many. So by all means, focus on the firms which do have sports practices and do have enough work where you could focus on it and try and qualify into it. But definitely don't think that's the only way in. We've just recruited, we've been overwhelmed. So we just recruited 1 newly qualified trainee and 3 lateral recruits. And 2 of them have done a bit of sports law, but 1 of them hasn't done any. And I don't care, because although we may say otherwise to people, sports law isn't that difficult. You can pick it up. You know, it's no more difficult than anything else. So what I'm looking for is people who've got really good background and experience in, don't really care what kind of law it is. I suppose if I'm looking for a litigator, then you have to be a contentious lawyer. But one of the best sports lawyers we ever hired was a tax lawyer from Linklaters, a guy called Rich Hawkins. He's now in our Sydney office. He spent a lot of time as the general counsel to the Australian Rugby Union. Excellent sports lawyer. He had a tax law background. So you could do employment law, you could do competition law. I think Tom mentioned it's a big part of sports law. You could do sort of disciplinary regulatory work. There are a number of ways to do it, and if you can aim for a training contract. You really are doing very well if you get one in a sports practice, or you can say, well, I'll go and I'll qualify in a good firm. I'll qualify. It doesn't really matter what area. It matters other than contentious, non-contentious, and I'll keep interested in the sports sector. I'll keep reading the press and the investigative journalism about sports issues. I'll write an article here. I'll join an organisation. I'll be a pro bono lawyer for a sports organisation. I'll volunteer for a committee. I'll show my interest and my commitment that way. And then when I'm a 2nd or 3rd year or something, I'll look out to transfer into one of these groups. I think that would be my advice. Julian and Tom, I hope I haven't, you're not going to disagree with me.
Oh, let's see if we can. No, I can't. No, that's all very sad. I wouldn't dispute any of that. And to be totally fair, I mean, John is one of the very few lawyers who do sports law and nothing but sports law. Tom and I both have other client bases, and we do sort of a slightly broader spectrum of work than in terms of the types of clients we have for. I would add a couple of things there. I mean, I do think actually you've got to take account of sport is probably an area of life which is, and it involves passion and sort of personal investment, almost like no other area of life that I can think of, frankly. Maybe the arts, sort of theatre and music might be close comparators. But I mean, I can remember having conversations with a former owner of a football club, and I knew him outside of football, and he was the most charming, lovely man. But when I got to talk to him about football and his club, he became something of a monster. And it just sort of it's the passion that it embroils in people. And so from the legal side of that, I mean, you do need to genuinely show an interest and understanding of sport, or a particular sport if you want to be very much closely involved with that particular sport. You know, you could be the best tax lawyer in the world, but if you don't have the ability to have the conversation with your sporting clients on the basis that you know what's happened, and you've got some sense of what's going on in terms of what's happening on a day-to-day basis within sport, I think you're going to find it quite difficult. And I mean, both Tom and I can't speak for John's background, but both Tom and I were very lucky in that we played sport at a pretty decent level. And I think the fact that we crossed the white line gives us a different insight and a better understanding of sport. We understand what's involved, you know. Having been in a changing room in a playing some significant sport, you get a different insight into what makes athletes tick, for example. Understand the passion of what we call the alacadoos, the people who wear the blazers upstairs, why they're so interested in their sport. And I think that gives you an added advantage. Now, that's not everybody's going to have that opportunity to do that, but if you've got that in your locker, then you've certainly got a head start. And I think if you haven't got it, then as John says, you've got to work hard at building up your knowledge, your contacts in the sport or sporting industry more generally, in a way that if you want to get into another industry, I would advocate you did that too. You know, if you want to be very big in chemical industry, you need to know all the players. You need to know what the issues are. You need to be able to have conversations with people in that sector, demonstrating you know and understand what's going on. And you need to build that up over time.
Perfect. Yeah, thank you so much. I think we've covered anything. I'm not sure, Tom, if you have anything to add or if that's kind of covered everything.
No, the guys have covered it. Thank you.
Okay, perfect. I am conscious of time. I know we've gone past the hour. If you guys want to go, it's absolutely fine. I just want to say thank you again so much for joining us all. I'm not sure if there's any more audience questions. There's no other hands up. But just because otherwise we could sit all day. There's one more. Do any of you guys need to go, or have you got 2 more minutes?
Carry on.
Okay, perfect. Thank you. We've got a question from Ash. Ash, you want to unmute and ask your question?
Hi, yeah. Firstly, I just want to say thank you for a really insightful talk. And then I just wanted to ask, on a more personal level, what would you say is your biggest or most memorable experience working in the field?
Who's going first?
Oh, I think Tom's turn to go first.
Yeah, no, great. Thanks, guys. Yeah, I'll go first. Great question. Really great question. I think I have found being in the sorts of meetings I've mentioned, the most rewarding, the most challenging, in rowing, in athletics, in golf, I've mentioned, in gymnastics, in many of the other sports that you can think of, in tennis, and making sure that we get the right sort of result. But probably my most rewarding and satisfying piece was completing this strategic alliance between the European Tour and the PGA Tour, because I actually think that is not only groundbreaking, but history will look back on that as a really important moment in the structuring of the sport and how it will look going forward. and liaising with the top decision makers of those two organisations on that was really, you know, I mean, that's just the dream job. I mean, that was just that's exactly what I was trying to, you know, spend my career sort of thinking I'd love to work on top work like that. That was the one. Over to you guys.
Go on, you go first, John. I'll finish up.
Okay. Well, the Russian doping cases have been very, very high profile and significant, and involved a fair amount of geopolitics, let alone sports law. And the Semenya case is a really fascinating case and almost a quintessential sports law issue, because it's about whether or not you are allowed to draw lines to try and create meaningful competition. And if you do, and if you exclude people, whether you've got a legal basis to do so. So they're both high points, but both of those cases I've been roundly abused by people for the positions we've taken. So I'm not going to choose those as my favourite issue. Instead, I will choose back in 2003. We helped the British Darts Organisation to get darts recognised as a sport. It wasn't being recognised because they said there wasn't enough physical activity involved, and that upset darts players a great deal. And we launched both a PR and a legal campaign, which successfully got them recognised as a sport, after which they reacted in two ways. One was they called and said, "Can you now please get us into the 2012 Olympics?" I said no. And the other thing they did was they gave me my own official darts name and my official darts shirt. So I'm now John the Truth Taylor. And if that is my epitaph, then that will be okay with me.
Good story. Good story. I like that one. I was asked similarly this question by chance over the weekend for my school wanted to do an interview with me, and the things that I find being most satisfying are invariably things I can't talk about, and it's because a client comes to you with a problem which is potentially causing them a great deal of anxiety and upset. And what you're able to do is to step in and resolve that problem for them, take away the concern, the worry, and the issue itself, so that actually they're able to move on in their lives. And those cases aren't always the biggest cases. They can be, on the sort of scale of what all of us do, relatively minor, but actually the lasting impact that you have on that individual, and it normally is an individual, can be quite long lasting actually. So there isn't one case in that respect that stands out, but those are the sorts of cases where you have a significant input. So, for example, the sort of Premiership footballer was being blackmailed this summer that I was involved in sorting that out. You know, not necessarily the biggest case, but creating a great deal of anxiety for the individual and family. And by being able to hold their hand and guide them through it, you were able to resolve that issue for them. So it's one of frankly many examples where that's happened. So not quite the sort of front page news type story, albeit some of the stories are front page news, but they're the ones where actually you have a real impact on an individual's life.
Perfect. Thank you all so much. Yeah, I mean, they all sound really interesting and things that I had no idea about myself, and I'd quite like to get my hands on my own kind of darts title now. I think that's all we've got time for. Apologies, run over everyone a little bit, but thank you everyone who joined. Thank you all to our amazing speakers as well. Thank you all so much for joining us, and thank you for attending the event. I think that's everything we've got. I don't think there's any more questions, so I'll let everyone go who's joined. And again, thank you all so much to Tom, Julian, and John for joining us again. And thank you for being on the panel. I really appreciate it.
Yeah,
Hannah,
thank you so much. It's been really insightful.
Hannah, thank you, and you and your team. And it's run over because you had 3 lawyers who obviously given a platform, they can't stop talking.
I mean, I could say I'm the same. People want me to pack it in at the end of the day, so I've got people around me like, come on, it's time. But thank you all so much again.
Thanks so much.
Thank you, everyone.
Brilliant. Thanks, guys.
Bye, everyone.
Thanks.